So good evening, everyone. It's exactly 6 o'clock, so we're starting on time. Thank you so much for joining us tonight, this evening, in person and also online. It is a very timely discussion of the implications of this very recent decision on Milieudefensie versus Shell. I don't want to say it's the first event because there might be have others, but I feel we are definitely one of the firsts, at least, to sit and reflect about this. So before I tell you what we're going to do, let me take 3 minutes or so just to put this in context and to give you the plan of this evening. So as I'm sure everyone here knows, in May 2021, the Hague District Court issued a landmark decision. I think it's fair to say that the world of climate litigation, similarly to Agenda, was not the same after that. So what the court did, it ordered Shell to significantly increase its emission reduction efforts. So the court held that Shell was legally obliged to reduce greenhouse gas emissions, to protect citizens from the adverse impact of climate change, and it went quite specifically to instruct Shell to cut emissions by 45% relative to 2019 by 2030. Do I need to do anything, Em? No? Oh, good. So this mandate covered not only the direct emissions from Shell, what we usually call scopes 1 and 2, it covered also scope 3 emissions, so indirect emissions from the use of Shell's products. So Shell appealed the decision, and after a series of hearings earlier this year, the Dutch Court of Appeal delivered its ruling just over 2 weeks ago on the 12th of November. That was a much anticipated decision, and what, as you probably know, the appellate court dismissed Milieudefensie's claim and ordered Milieudefensie to pay Shell's legal costs. So at a first glance, and I think that was also the first immediate reaction when we were live following the decision, it seemed like that was a significant victory for Shell. And that also maybe was added to the fact that a few months earlier, there was another high-profile case, again involving Shell, trying to hold Shell's directors personally liable for alleged mismanagement of climate risks. So if that was the immediate reaction, what we are going to see today, and I'm sure you already read about, is that the story is not so straightforward. So I really think it's our role, and I'm really excited and looking forward to, together with this amazing panel, understanding more the nuances and the complexities of the case and of the decision. So looking closer at the ruling, we see that the court didn't really entirely reject the 2021 judgment. Instead, it dismissed many of Shell's arguments and also offered some valuable guidance on the responsibility of multinational corporations in addressing contributions to climate change. Not only that, I think it left many doors open both for an appeal, which we'll hear maybe soon if that's happening, but also for future litigation. So today, welcome all of you who came just now. It's amazing to see such a full room on a dark November evening. So today, we are very fortunate to have a very diverse panel of experts that will help us unpack the implication of this judgment. The idea from the start was to really have a space for reflection. Many of you here in the room know also a lot about the case and the decision and litigation in general. So we are also hoping to have a quite informal and conversational, hopefully also debate after. So the panel, I will introduce you soon, will speak for around 40 minutes. And then we're saving a good 30 minutes for Q&As. And this is what I mean by hoping to have a great discussion with the audience in person and also the audience online. M will be in charge of the audience online. For the audience in person, people have microphones and you will be raising your hands. So that was my brief introduction to this evening, and I want now to introduce this excellent panel. So beginning with, and I'm sorry if I mispronounce, Shoki van Oosterhout. I will improve my Dutch, especially if the Dutch courts continue to give so many rulings, and eventually we all have to learn some Dutch. So Shoki is a senior team lead at Milieudefensie, so we brought the right person to speak about the case. She has been involved in leading this groundbreaking case against Shell, and she also has a decade of experience in climate policy consulting, especially on greenhouse gas accounting and analyzing corporate climate plans, strategic international advocacy. Importantly, she holds an MSc from the LSE, and you will see actually that all our panelists have studied, worked, and so it's a very LSE panel. It's just a coincidence, or just the fact that there's so many people at LSE doing amazing work out there. So our second speaker then will be Noah, Dr. Noah Walker-Crawford. He is a postdoc, a research fellow at the Grantham Research Institute, leading a really new, exciting project that we have looking at the role of climate science attribution in shaping litigation. Noah has a PhD from Manchester, and he's been a postdoc at UCL, visiting at Harvard Kennedy School. Also, Noah has been very involved in many of the cases, particularly the case of Liuya against RWE. Then Dr. Fergus Green, who is now an associate professor at UCL in political science, but has also a long history working with us at the Grantham. His research spans across political theory, political economy, and public policy and law. He was a lawyer in a previous life in Melbourne, where he worked on climate and energy. Then he was a policy analyst and a research advisor to Professor Nicholas Stern here at GRI. He did a PhD at LSE in the Department of Government. He has published widely on governance of fossil fuels, including a recent paper in Science, and contributed to the UN Environmental Fossil Fuels Production Gap Report. Also important already to disclaim here, Fergus was engaged by Milieudefensie to provide expert evidence in the appeal stage of its case against Shell. Then, last but not least, Isabella Kirchning, who is a legal officer at Opportunity Green, leaving that role and embarking soon in a new journey. But she's been working there, working with law, economics, policy to tackle climate change. She has also worked with us at the Grantham Research Institute, helping us in several projects, including one of the papers that she will be mentioning here. Isa has an LLM in transnational law from King's and a master's from the University of Zurich. So this is the amazing panel that I was telling you about, and they're here in person, 3 of them and 1 online. And now we will progress to the actual panel. So I want to first invite Shoki to tell us about the case. So to set really the grounds for this conversation and her reactions on the ruling and what's forward. And then we'll follow in this order. So now that's enough for me. Let's start. Welcome everyone again. Looking forward to this discussion.
Yeah, good evening, everyone. I hope you can all hear me. Yeah, so I'll share a little bit about the background of the case, the ruling in 2021, and the most recent judgment that we had on the 12th of November, and a little bit about what's next, to the extent that I'm able to share it. Let me first very briefly mention why we started this court case against Shell back in 2018 already. It's been a couple of years. We strongly feel that big polluters, big companies also have their own responsibility to stop dangerous climate change. And we felt that there was this so-called governance gap, that states and governments weren't really able to regulate these big polluters and these big companies. So we felt that a court case was the best way forward. Then how did we land on choosing Shell? Well, there's only 4 countries that emit more than Shell. It's one of the biggest polluters worldwide. Shell has been knowing about climate change and the role that fossil fuels play for many decades. They call themselves a leader in the energy transition, but they're lacking any sort of serious climate targets. They continue investments in oil and gas. They currently have over 800 new oil and gas fields still in the pipeline. Importantly, they were based in the Netherlands. So back in 2018, they were based in the Netherlands, and that was helpful for us in terms of the jurisdiction, basically. So we started this court case back in 2018. A lot of people thought we were crazy at the time. But in 2021, we actually won the case. The District Court of The Hague ruled that Shell needed to cut its emissions with 45% in 2030 relative to 2019. Which was, as Joanna said, groundbreaking. Was the first time that corporate was held responsible for its CO2 emissions. There were a lot of interesting elements in the 2021 ruling. If you haven't read it so far, I would encourage you to do it. Even now, it's an interesting read. It's about 50 pages, so won't take you too long. But it clearly says that Shell has a responsibility of its own to respect human rights. Shell has a responsibility of its own to prevent dangerous climate change, and that reduction obligation, that 45%, is for the entire value chain. So it's scope 1, 2, and most importantly, scope 3, which is where 95% of Shell's emissions are. Then after 2021, a lot's changed. Shell moved to the UK. They said it wasn't because of the ruling, but who knows? They also got a new CEO, and this new CEO really doubled down on fossil fuels. So one of the first things that he did was he let go of the target to cut oil production. Also, the investments in wind and solar went down. Most recently, back in March, their climate ambitions and their targets were lowered. People were let go in the renewables department. So since the ruling in 2021, Shell moved the opposite way of where it should have been going, because the ruling in 2021 was clear that Shell needed to start cutting its emissions immediately, which obviously didn't happen. Now fast forward to, 2 weeks ago, the ruling of 12 November. I think if you Google for photos of the judgment of that day, maybe you will find crying people outside the courts. Well, I'm going to say I wasn't one of them. I'm not a big crier myself, but also I think pretty early on, we kind of found that even though the judge let go of that 45%, there was a lot of good things in the ruling that we can build on, both in and outside of the courtroom. And one of the big ones is that the court said once again that Shell and other big polluters have an obligation to combat dangerous climate change. The court was also very clear that Shell cannot hide behind governments, they cannot hide behind consumers. Protection from dangerous climate change is a human right, and Shell has a responsibility of its own to respect that. Shell must make an adequate contribution to achieving the Paris climate goals. And that responsibility is, again, not just for scope 1 and 2, but also for scope 3, which is where 95% of Shell's emissions are. It also very specifically says that large companies that have contributed to causing dangerous climate change, such as the fossil fuel industry, have a special duty on this planet to help combat dangerous climate change. Another thing that's really important is that the ruling highlighted that investments in new oil and gas fields could be at odds with the Paris Agreement. As I mentioned before, Shell is still very much involved in starting new oil and gas fields. Science has been clear for a long time that that's not possible if we want to live in a world where we want to limit warming to 1.5 degrees. But our research showed that Shell still has over 800 of these projects. And the court was very clear that that could be at odds with the Paris Agreement. Now, the court could not tell Shell to stop new oil and gas fields because we didn't ask for it. One of the questions that you may have is, why didn't we ask for it? Well, back in 2018, when we asked for it, the science wasn't as clear. Maybe if we would start a new case right now, we would ask for something like that, potentially. Another really important thing that the court said in that ruling on 12 November is that Shell and other fossil fuel companies have the power and the influence to prevent dangerous climate change. Also that existing legislation, such as European legislation, the ETS or the CSDDD, does not prevent individual companies from having a more far-reaching obligation to reduce their emissions. So it doesn't indemnify, if that's the correct English word. Another really important thing is that fossil fuel companies have a responsibility to reduce their supply regardless of demand. And also the court clearly sees a role for itself in this whole thing. The court can intervene if a company fails to fulfill its duty of care to limit its emissions. And the court even says that there's no reason for the court to hesitate to do that. Well, why did we still lose? Because this is all great stuff. Unfortunately, the court shielded away from putting a specific reduction percentage because they claimed there is insufficient scientific consensus. I think we'll hear more from the other panelists on that, which is, of course, a shame. I think if I can maybe already say one thing about it is that one of the things the court said is that there were too many percentages and too many expert opinions. One of our experts in the procedure on this was an IPCC lead author, whereas one of Shell's experts was from an institute funded paid for by Shell. And that expert came up with percentages as low as 2% and 7%, which, is not really in line with what you would expect of one of these major polluters. Another thing that the Court of Appeal considered, which we'll also hear more on from someone else in the panel, is that the court claimed that a reduction obligation wouldn't be effective. And because Shell would be allowed to reduce its emissions by selling less oil and gas, and that would, according to the court, not help the climate. The court said that producing less oil and gas may help the climate. Well, we have a different perspective on that, but I think, again, someone else in the panel may have some reflections on that. So I think overall, there is a lot in the ruling on the 12th of November that we can work with, that can be a foundation for further litigation, for further campaigning, for holding big polluters accountable. It is, of course, a shame that the court didn't uphold the 45% reduction percentage. We have the possibility to go to the Supreme Court, the highest Dutch court, so-called cassation. We have until the 12th of February to decide if we want to do that. And I can't give you any new information tonight, unfortunately. We're still considering if we're going to do that. But I think it's important to say that we are considering all sorts of possible options against Shell. I think if there's one thing that's clear is that we're not gonna back down, and we're going to continue to keep holding Shell accountable in whatever way that will be. One thing that we have already done is announce that we are continuing with our court case against ING. We are currently writing the summons, and we feel that this judgment offers a lot of opportunities for us to continue that case. ING is one of the biggest funders that also still invests heavily into new oil and gas fields. And as I already mentioned, the court was very clear that big companies have a responsibility to cut its emissions. So we will be going ahead with that court case. Yeah, I think I should leave it at that for now. Yeah, thanks so much.
Thank you. Thank you. That was excellent. It was exactly what I was hoping in terms of presenting the case and what are your initial reflections. And I think there's going to be a lot here now to follow. So our next speaker panelist is Noah, and Noah is going to speak about the engagement of the court with the science in general, then Fergus in more detail. Noah.
Yeah, thank you, Joanna, and thanks, Choki, for giving us a really great overview of how this case emerged, kind of the reasoning behind it, and the outlook after the ruling from 2 weeks ago. And I'm really going to build on that and talk a bit more, like Joanna said, about the court, how the court engaged with the science, specifically around this point of what should be the emissions reduction obligation for a company like Shell. And so in a lot of ways, the outcome of this case is a bit bizarre because, like we just heard, the court was saying, yes, Shell has a responsibility. They need to take action on climate change. They need to help us achieve the Paris goals. But they couldn't quite figure out by exactly how much that should be or what exactly they have to do. So basically, the court is saying that, yes, Shell should reduce its emissions, but we don't know precisely by how much they should do that. And so basically, the court said, like we just heard, that they found a lack of scientific consensus around what level of emissions reduction is necessary. And so this 45% figure came from the IPCC, the Intergovernmental Panel on Climate Change. And this is basically a global figure. So saying that to keep in line with the Paris, with the goals of the Paris Agreement, so to try and limit the global temperature rise to 1.5 degrees, as a whole, all of us across the planet, we need to reduce our emissions by 45%. So the logic of this case was fairly straightforward. If we all have to do it, then Shell has to do it to do this as well. But the issue here is that, according to the court, is that 45% for all doesn't necessarily mean that everyone has the same responsibility. Some might have to do more and others might have to do less. And really, this issue speaks to a broader challenge with climate litigation, namely that it draws on very complex science, different aspects of climate science, which has developed very rapidly. It's getting better and better in terms of giving us a very solid understanding of what's going on with climate change, who's contributing how much, what kinds of emissions is that causing, and crucially, what action is needed going forward to prevent climate change from getting even worse. But at the same time, this is an ongoing scientific conversation, even if there is a lot of, there's more and more consensus, especially around the basic facts. And so even in this case, there was consensus around this fact that globally emissions need to be reduced by 45%. But of course, with any kind of science, there's going to be underlying uncertainties. And so this is a real challenge for courts to deal with, or first of all, for lawyers to understand what the science is saying, and then to communicate that clearly to courts, and then for judges to take it into account in their legal reasoning, in their ruling. And so In this specific case, as I said, there is a broad consensus on this global figure of 45%, but that can be distributed in different ways. And so basically that means in practice that some sectors might have to decarbonize more quickly than others. So to give you some examples, for the energy sector, it's often seen to be easier to decarbonize because renewable energy is becoming much more viable these days. While for other sectors, it can be difficult. So things like aviation, shipping, or some forms of heavy industry where the alternatives to fossil fuels aren't necessarily so financially viable yet. And so when we have this kind of a broad emissions target, it's easier to apply that, for example, to states. So we've seen this, or quite famously, one of the first big examples of this was the Urgenda decision. So the Urgenda case was the case brought against the Dutch government a few years earlier, and this was one of the first big success stories in climate litigation. And so there, the court ultimately it said that the Dutch government had to reduce its emissions by 25%. But of course, the government can then decide how those emissions reductions should be distributed across society, across different sectors and industries. And this becomes a bit more complex when we get to individual companies, because on the one hand, we could apply this global figure, but then some say that some companies might have to do more than others, as I was talking about earlier. And so that's essentially what the court was saying here, that they couldn't determine specifically what Shell's emissions reduction obligation should be. But we might take that to mean that that leaves the door open for if there's a clear scientific consensus, or if, we might say, the court listens to the IPCC lead authors over the Shell-sponsored authors, that they might come to a clear consensus on what kinds of emissions reductions are needed for a company like Shell. And so it's important to say that the research in this area is advancing rapidly as well. And so there's been a lot of discussion in the science about fair shares, about how responsibility should be distributed. And this is quite a key principle under the the global climate governance framework. So under the UN climate discussions, what's been called common but differentiated responsibilities. So the idea is that those countries that have produced the most emissions, they have a bigger responsibility to take more action, and that also means to reduce their emissions more quickly. And so more recently, there have been discussions applying this to companies as well, saying that a big company like Shell, they've made a much more massive contribution than others. So actually, maybe this figure of 45% might even be too low for them. Maybe they should be doing a lot more than that. There have been some initiatives that companies have been a part of as well. A lot of companies have developed their own emissions reductions targets. For example, there's an organization called the Science-Based Target Initiatives, which supports companies in doing this. It validates their emissions reduction targets. But there has been some critique in how companies have been going about this, calculating this so far. So on the one hand, there's some critique that when companies talk about how they're going to reduce their emissions, especially thinking about longer term targets like up to 2050, saying net zero by 2050, that might be relying on certain technologies that don't exist yet, like carbon removal, carbon capture and storage, where we don't have certainty that that's actually going to be so viable in the future. So actually these targets might be relying on things that aren't necessarily possible. And then another point of critique is that if we kind of go off where companies stand at the moment, say that Shell, for example, has to reduce its emissions by say by 45% from its current level, that actually favors Shell because it favors companies that already have emissions at such a high level. So ultimately, that's reaffirming the status quo, because big companies like Shell will, in the meantime, still be able to emit at quite a high level because they started at they've been emitting so much up into the present. And so ultimately here, the courts need clarity from the scientists. So it's great to see that research in this area is advancing so rapidly, but we really need good research from the scientists, and we need the scientists to communicate this very clearly as well, so that the judges can understand what's going on and can understand what needs to be done. So even if this case wasn't successful, with the advancements in the science, that gives us hope that these sorts of cases will have a lot more success in the future.
Perfect. Thank you so much, Noah. And I think that this it was all really a lot of things for us to discuss. But the point where you ended, that the courts need more clarity and scientists need to communicate clearly, is a perfect link to where Fergus will come in, because he will tell us about what the evidence that he and colleagues provided, how the court responded, what the frustration maybe is, and what do you see as doors maybe that are still open. So Fergus, to you.
Great, thanks, Joanna. Yeah, so one of the arguments that Shell made on appeal was that even if the reduction obligation imposed on it by the district court was upheld by the Court of Appeal, and even if Shell actually achieved that reduction, that it still wouldn't be effective in reducing net aggregate global greenhouse gas emissions, because essentially other companies, other fossil fuel producers would substitute Shell's activities in the oil and gas marketplace, right? Now, I think it's worth just reflecting on the sort of how extraordinary that claim is in a sense. So Shell, as we've heard, has more emissions than almost every country. Scope 1, 2, and 3 emissions of around 2% of global annual emissions in 2023. And it's essentially saying here that even if it has to reduce those emissions by 45% over a 10-year period, that would make no difference to the global climate. So in my opening remarks, I'm going to elaborate on the specifics of that argument by Shell. It's what's known as a market substitution argument, and it's a common pattern of argument that is made in litigation against new fossil fuel projects. So I'm going to look at the specific variants of that argument that Shell raised. I'm then going to look at explain how we responded to that, and by we I mean myself and co-authors who were engaged by Milieudefensie to write 2 expert letters on these issues in the appeal stage. And I'll explain what the court found, and at the end comment briefly on the significance of its findings on the market substitution issues for other litigation against fossil fuel companies. So just an important point of background, once we get the slides. Yeah. It's important in order to understand the market substitution arguments, to have a sense of the composition of Shell's emissions. And I'll just go through these quickly, given it's already been alluded to. But so Shell's Scope 1 emissions, they're the emissions from Shell's own operations. So things like the venting and flaring of methane that happens in the process of extracting oil and gas. And its Scope 2 emissions are the emissions produced from electricity and heat that are used in Shell's operations. These are only around 5% of Shell's total emissions, as you can see on the chart there. The rest of Shell's emissions, the other 95%, are from what's called Scope 3 emissions, which are basically emissions that occur in an entity's supply chain, but that are under the control of another entity. And so in Shell's case, most of those Scope 3 emissions are emissions that are produced from the combustion of the fuels that Shell sells to its customers. So if you go and drive your car after you've filled up from a Shell service station with petrol, then the emissions from you driving your car would go on Shell's books as a Scope 3 emission. So it's important that the district court said that Shell could comply with its reduction obligation, however it chooses, as long as it meets the 45%. And that's important because Shell basically said that, well, there are 2 main ways in which it could comply. And I should say that it was commonly accepted, given those figures you can see on the slide, that in order to meet that 45% target, that Shell would have to reduce its Scope 3 emissions. But Shell on appeal said that, well, there are two main ways in which it could reduce its Scope 3 emissions, and neither of those would be effective in reducing aggregate emissions because of market substitution. And so I'm going to go through those two arguments now. So the first scenario is where Shell reduces its own fossil fuel production, its own oil and gas production. And so here, Shell says that if it was to, the animation's not working, that's fine. That's fine. Here Shell says that if it were to reduce its own fossil fuel production, that wouldn't have an effect, because what would happen is that other producers, that the demand for fossil fuels would stay the same, and other producers would just supply the fossil fuels to the end customers. Now, we argued that that is contrary to microeconomic fundamentals and to empirical evidence on how oil and gas markets function. So any first-year economics student will tell you that if you decrease the supply of a good, it will shift the supply curve to the left, and it will increase the equilibrium price of that product, and that will lead to a contraction in demand, a reduction in the quantity demanded. And it turns out that oil and gas markets also function that way. Now, the precise slope of the supply and demand curves differ from the stylized example I have there, but nonetheless, we can expect that the direction is clear, that if Shell reduced its supply of oil and gas, that would lead to a reduction in demand for oil and gas and a reduction in emissions. Now, the court seems to have accepted our evidence on this point. It doesn't address it in any detail, but it basically says that there may be a causal relationship between a production limitation and an emissions reduction. But read in the context of the other things it says, it seems that they agreed with us on that point, and I'll comment on the significance of that later. But the court didn't really address the evidence in any detail, and in fact, it focused most of its attention on the second scenario by which Shell could reduce its emissions. So to understand this, its Scope 3 emissions. So to understand this second scenario, it's necessary to go back to this. Next one. Thanks. It's necessary to kind of go back to this point. So the blue area, the Scope 3 emissions, only about 1/3 of those are attributable to the oil and gas that Shell itself produces and on-sells to its customers. The other roughly 2/3 are attributable to oil and gas that's produced by other producers, which Shell purchases and then on-sells to customers. And so Shell argued that it could essentially meet its emissions reduction obligation by ceasing to sell that third-party oil and gas. And that wouldn't change the amount of oil and gas that gets produced. And Shell's experts said that that downscaling of Shell's trading operations, the Shell trading operations, would not have an appreciable impact on the price of oil and gas. Now, we disagreed. We argued that Shell provides a range of intermediation services, refining, transport, storage, handling of oil and gas, and therefore it adds significant value in the marketplace, and that if it were to exit those activities, that would lead to a reduction in supply, essentially. So the same logic, it would increase the price and reduce emissions. Now, unfortunately, the Court of Appeal said that Milieudefensie had failed to produce sufficient evidence that limiting the third-party sale of oil and gas would lead to a reduction in emissions. The reasons for the court's decision here, I have to be honest, are really not very clear and somewhat convoluted, and they sort of misquote us and misunderstand our evidence. So that was quite disappointing to see that. I won't go into the specifics, but happy to kind of pick this up in the Q&A. So, but I'll just conclude by commenting on the significance of the court's somewhat mixed findings on this market substitution issue. I think it's important to focus on the fact around that first scenario, the fact that the court, albeit somewhat tentatively, seemed to think that a reduction in Shell's own supply would lead to an emissions reduction. I think that's significant in the context of global climate litigation for two types of climate litigation. First, it's significant for the more common type of litigation, which is against new fossil fuel projects, often on environmental or planning law grounds, in light of their Scope 3 emissions. And this case, again, albeit tentatively, adds to a growing roster of cases that is rejecting the market substitution argument that fossil fuel companies make, including a recent UK High Court case on the Cumbria coal mine and a number of decisions in Australia and the US. And so I think this will add weight to that growing body of precedent that's rejecting the market substitution arguments. And then secondly, I think the court's finding on market substitution is significant for other corporate framework cases like the Shell case. And in this respect, it's significant in the context of Shell's finding, of the Court of Appeal's finding on the law regarding the scope of Shell's duty of care. And as Shukya mentioned, the court sort of made some remarks in obiter that essentially suggesting that that Shell might be in violation of its duty of care in virtue of its planned investments in new oil and gas production. And so if that is the case, if the duty extends to not engaging in new fossil fuel production, then it's significant, therefore, that the court found that that forbearance would, or at least may, have an effect in terms of reducing global emissions. So essentially, I think the court is sort of strongly suggesting that there is both a legal and a factual basis for finding that fossil fuel companies, for holding fossil fuel companies accountable in tort law, at least in the Netherlands, possibly elsewhere, for their new investments and activities in oil and gas production. And I think that's particularly significant because it sort of, in my view, it suggests that we're kind of edging a little bit closer to a global moral and legal norm against new fossil fuel projects, which is something that in a recent article in Science, myself and my co-authors have argued should be an increasing focus of climate governance. Thanks.
Excellent. Thank you very much, Fergus. Amazing. So look, we are doing all right with time. We now go to Isa to hear about this case in the broader context. This is not the only case, and there are many others that are similar but not identical. And this is what we will hear from Isa as the last panelist. Thank you, Isa.
Thank you, Joanna, also for the invitation to speak. It's a pleasure to be here tonight with all of you. So I will be taking a step back, as Joanna said, and we'll be reflecting on the larger picture, as this case is one of many what we call corporate framework cases, so cases against large corporate emitters, which seek to align these emissions trajectories with the goal of the Paris Agreement. Now we have around 20 of such cases that have been filed around the globe in over 10 different jurisdictions. We see such cases filed in Germany, in Switzerland, in France, but also in New Zealand and the Philippines. And many of them are ongoing. Some are pending, some have been appealed, a final decision is yet awaiting, and some, especially this year, have just been given the green light to proceed to trial. So it's a very, very dynamic field. And while many of these cases are being brought on the basis of tort law, as is the case here in this case, other cases, and also this case, also draw on international soft law instruments and international human rights standards. And in France, for example, the adoption of due diligence legislation, the so-called duty of vigilance law in 2017, sparked a number of cases, such cases, against both corporations and financial institutions. And interestingly, while you might think that these cases only target oil and gas companies, we see a real variety here. So we also see the agricultural sector being targeted, the financial sector being targeted, cement industry, and even the car industry. And while many of these cases are inspired or draw on the Shell case, they're also distinct. And it's important to keep these distinct aspects in mind when we compare these cases. And just to name a few aspects, as I mentioned before, they're brought in different legal contexts and in different legal jurisdictions. They also make very specific claims, which might differ from the claims that we're seeing here. and they target different sectors. And then lastly, we might also see different emissions portfolios of the defendant companies. And to really highlight how this field is dynamic and diverse and how it's constantly evolving, I would quickly like to mention a case that we've seen being brought by 4 islanders of Pari against a cement manufacturer in Switzerland, where the islanders are basing their claim on Swiss tort law, and they're making 3 main claims. The first one being a forward-looking emission reduction claim, comprising scope 1, 2, 3 emissions. We've already heard from Fergus what that means. Here we can see the inspiration being taken from the Shell case that we're discussing tonight, but it's also including a backwards-looking claim. And this is maybe something that we think of more when we think of corporate climate litigation. It's a typical polluter pays case where they're claiming for loss and damage with relation to climate change. And then lastly, they're also asking for financial contributions to the adaptation measures needed on the island. And when we look at the defendant company, it's first of all a cement manufacturer, so it's a different sector that is being targeted. But also, interestingly, when we look at the emissions portfolio, around 2/3 of emissions are actually scope 1 emissions. So it's just a different case, even though it's inspired by the Shell case. However, nevertheless, in many of carbon majors emissions portfolios or otherwise large emitters, when we look at them, scope 3 emissions will comprise the overwhelming majority of corporate emissions. And this is also why, together with Joanna and a group of researchers, we are looking into corporate responsibility and liability for scope 3 emissions in these corporate framework cases, as all of these 20 cases either implicitly or explicitly seek to address this emission group. And we've heard from Shelke why, in the case of Shell, for example, this is so important. We're talking about 95% of emissions in some cases. So disregarding this emissions group would be really reducing what we're talking about in terms of contribution to climate change. And in our research, we've got some preliminary findings, and this is that we see different questions popping up when we talk about scope 3 responsibility and liability, both of procedural nature, of evidentiary nature, and of substantive legal nature. And I'd like to mention specifically the evidence and also some substantive legal question, kind of tying it back to what we've heard from Noah and Fergus. And the first one ties to the scientific evidence. As Noah showed us, it might be difficult when we talk about global emissions reduction pathways to establish sectoral pathways, as was the case in this case. However, while the case here was focused on a specific emissions reductions claim, other cases may choose to include a number of claims. This is also something Shelke alluded to. And Shelke also said that the Court of Appeal kind of really made a big hint that investments into new oil and gas fields might be at odds with Shell's duty of care. And Shelke has talked about the ING case, which Milieudefensie is planning to pursue, but we also see other cases, other corporate framework cases, which have already picked up this claim. For example, a case similarly being brought against the French bank BNP Paribas. And when it comes to the economic evidence, Fergus has talked us through market substitution. And this is being used in many of these cases to evade responsibility. But ultimately, it's an important one to address because it ties into the effectiveness of the claim. And ultimately, if a court finds this is not the case, then there may not be a legal interest to bring the claim in the first place. However, something that we've not touched upon as much, which was also discussed under the effectiveness of the claim, is that the Court of Appeal quite firmly rejected Shell's arguments that it does not have control or really influence over its scope 3 emissions, because Shell was arguing that would effectively constitute third-party liability. And the court said that this does not hold water. It was really very clear on this argument, whereas it rejected it. And this is also an argument that we see play out across many corporate framework cases. So this may indeed boost other claimants' cases. And when it comes to substantive legal questions, I want to mention something again that also Shelke alluded to. And that is that we see such a large number of obligations under EU public law. The CSDDD has been mentioned, but a number of EU instruments. However, the Court of Appeal said these obligations are not exhaustive and that Shell has a separate duty of care to reduce emissions across scope 1 to 3 emissions. And this is really interesting finding for me, because when we look at, for example, a number of corporate framework cases that are being brought in Germany against car manufacturers, these have so far been found unfounded. So they've been dismissed by the courts. They're currently appealed before the Federal Court of Justice. And in previous instances, the court seemed to place quite a considerable weight to the argument that all these car companies are complying with existing laws. So it will be interesting to see whether the Federal Court of Justice may be swayed by these findings. So this is a really important finding, in my opinion. So I think it's fair to say there are many hidden Easter eggs in the ruling, as we've discussed, and this may not be the end of corporate climate litigation. Instead, the case really reaffirms important positions on human rights and climate change, but also the general corporate responsibility to reduce emissions across all scopes. However, as we've heard on the panel, it also sheds light on some of the difficulties to liability. So to really establish what a concrete company must do, so translating what we know is needed in terms of the global level, but translating that to specific sectors and to a specific company. And with that, I will hand back to Joanna.
Thank you. Thank you so much, Isa. This was excellent. We've covered the case, the challenges around the science, the specific issue around the market substitution, this case in context. And I know we were supposed to do a round of where I would follow up with questions. That was our plan, you know, that's the usual plan in panels. But I don't think I've ever seen this room so full, and there's so many people here who I'm sure have questions and comments. So both are welcome. If you don't mind, panel, I would suggest we skip the round of follow-up questions that I had, and we open to the public in person and to the public online. I already see Paul with his hand off. Thanks, Paul. And yeah, you can introduce yourselves. Paul Benson can introduce himself when I don't know the names. And so we start with you, and think about your questions, raise your hands, and we will collect 3 and then answer and carry on like this as much as we can. Paul.
Thank you very much, Joanna. Paul Benson, Senior Lawyer at Client Earth. Hello to you all, and good to see you. Thank you for the very informative panel. 2 comments and a question, if I may. It strikes me from the judgment, and I think, Noah, you touched on it, that reading through the judgment, you would almost think that the court is going to find in favour of Milieudefensie, and then slightly throws its hands up and says, well, this is all very difficult, actually. Shell has this obligation to reduce greenhouse gas emissions in line with Paris, but we don't really know how to quantify it. Now, that's obviously difficult as a matter of sort of legal reasoning, because you're left with an empty obligation, but it also generates considerable legal uncertainty for companies, including companies like Shell, and so is not particularly attractive. And so I can certainly say, from my experience advising these companies in my prior life before joining Client Earth for over 10 years, legal uncertainty is anathema to these. They hate it. They hate legal uncertainty. And so I would have thought that that was a point, and I'm not going to ask you, Shakya, necessarily to comment on whether that might be a point which the Supreme Court would find attractive to decide upon, or which might lend itself to reinterpretation of the relevant duty. But just a comment that I wanted to make there. The second comment that I wanted to make was on market substitution, and Fergus, I've really found your presentation there extremely helpful. It strikes me again that this is quite a problematic finding, not only for the reasons you've described, but legally, in terms of the precedent, as I understand it, even in the Netherlands, whereby in the Agenda case, the Dutch Court of Appeal and the Supreme Court effectively dismissed the substitution argument that was made on behalf of the state. And then you have now, in this, albeit slightly different context, the court effectively upholding the substitution argument in favour of Shell, albeit with some nuance, which Fergus has explained. And again, from a legal standpoint, you would expect that that might be something the Supreme Court would be interested in having a look at and reassessing. Those are rather my comments. I suppose my question is for you, Sjoukje, which is whether that latter point is correct as a matter of Dutch law. And I'm not going to ask you to disclose, unless you particularly want to, your internal legal strategy and reasoning on those possible opinions. Thank you.
Thank you, Paul. Next question. Yes, please introduce yourself and feel free to use the mic.
My name is Pranjal Mathur. I work at Osborne Clarke as an ESG analyst. Thank you very much for this presentation. It's been incredibly insightful. Full disclosure, I'm not a lawyer, so maybe I've missed some nuance here, but my understanding is of the AR6, at least, that it unequivocally shows that climate change related risks are material and they hold significant materiality for any kind of institution. That's what my understanding is. And I guess my question is that when the AR7 comes out in the next few years, what exactly does it need to include? Does it need to call out oil and gas companies explicitly for it to be passed at this kind of a level? Does the AR7 need to explicitly call out oil and gas companies within its modeling? Does it need to explicitly take the names of companies? Like, what exactly will it take for a case like this to be passed without having to go to the Supreme Court? Thank you.
Thanks. And I think the mics might not all work. So now we have also these roving ones. Do we have a third last question? Yes. Just there next to Brenda.
Hi, thank you. Helen Russell. I look at social and political risk on behalf of project financiers. So quite often I'm involved in complicated multi-stakeholder deals where there's an awful lot of moving parts and lots of decision-making committees. And absolutely clear in all those processes is that need to everyone to be on the same page. Now, I was asked to investigate when Rio Tinto was blew up the indigenous peoples caves in Yukon Gorge in Australia for an impartial view. And it transpired through those investigations that actually Rio Tinto had jumped through every legal hoop that they could. They'd even gone beyond that and asked for representatives from the Ministry of Antiquities and Culture and Indigenous Peoples to be present at site to thereby give them permission on where they could blast. So in terms of liability, you know, I'm not quite sure what Rio Tinto could have done in that case, but it did raise a question in my mind in terms of, right, where are those roles and responsibilities in making sure that the legal frameworks that we have in place are actually adhered to, especially when you have a sort of fairly proactive and responsible partner in that very specific case, not defending Rio Tinto at all, but, you know, in terms of, I wasn't quite sure what they could have done. So in this case, I'm wondering, sort of where those roles and responsibilities lie. Because, you know, if you, as a government permitting authority, if I don't want my emissions raised, then I don't give a permit for an oil and gas refinery in my jurisdiction. Yes, I know the resources are there, but if it has to go for the arguments of energy independence and thereby, you know, financial contributions to the localized economy and all those good arguments as to why these projects go forward, then I would at least put in place some very strict stipulations about the conditions under which that process could be implemented. So I'm wondering in this case, sort of where that gap was in terms of the roles and responsibilities and why the hell they weren't put in place to avoid sort of that scenario. So.
Great, thank you. So I will distribute the questions, but you can also always answer and comment on other questions. And then maybe we will do a round of the online people who we have to respect people who are still joining panels online. And so let me start maybe distributing here. I think Paul's question goes to you, Fergus, on market substitution. Then maybe Noah, you can speak about Brangel's question on AR7 potentially being more specific about sectors. Then maybe Shuka and Isa, you can speak about the roles and responsibilities question that was asked last.
Yeah, thanks. So, yeah, Paul, just actually, before I get to market substitution, actually on the first point about the uncertainty, I think you've captured it nicely. So you have a responsibility to reduce, but, you know, yeah. So, I mean, I think, you know, I think we could perhaps take some inspiration perhaps from what courts have done in the state type sort of framework cases, like you mentioned, agenda. And in a number of these cases, sort of, I guess, courts are sort of willing to entertain a range, and they're sort of more concerned when, in that case, countries fail to do the minimum. And we saw this again in the Klima Signorinen case, and this is sort of follows in line with the European Court of Human Rights as environmental jurisprudence. So it's the court's role ends up being a sort of backstop to ensure that a certain minimum responsibilities are met. And I suppose if I was advising companies on the basis of the decision, I would probably point to certain things like having you know, an emissions reduction plan in place, having you know, a senior officer who's responsible for implementing that. So there's a kind of process procedures aspect and probably sort of minimum substantive obligations. And it's hard to know what they are, I agree. But here I think where it can be useful, and this is why I've advocated for a sort of norm building approach, is to try and articulate, and I mean the sort of the international climate community, right, NGOs and so on, and countries as well, to articulate some certain red lines that companies and countries, depending on the context, shouldn't go past. And I think the court, as we've discussed, hints that maybe a red line might be around investing in and undertaking new oil and gas production. And so if we can kind of build that norm, then that's potentially something that future courts could look to in interpreting the sort of minimum content of open-ended duties of care, like the one in this case. On market substitution, just quickly, so I don't think the contradiction is perhaps so stark. So I think the fundamental point is around that sort of, that's useful, I think, and that's perhaps not so inconsistent with the agenda case and what has been found in some of the more recent cases that have addressed market substitution, which is that, you know, ideally the court would have said reducing oil and gas production would lead to a reduction in emissions. It said it may do, but as I've said, it's kind of a tentative endorsement or rejection of the market substitution logic. And so hopefully, you know, one can build on that. I do sort of agree with you, though, that the way that the court treated the evidence on this point was not very satisfactory. I mean, basically, well, yeah, maybe I'll stop there. But basically, yeah, I'm happy to kind of talk to you afterwards about some of the nuances. But I do think that particularly the way it dealt with the kind of Shell trading aspect of selling third-party oil and gas was quite unsatisfactory. And whilst I'm by no means a Dutch appellate lawyer, I would have thought potentially appealable, just given the sort of flaws in logic.
Yeah, thanks, Fergus. And actually, there was part of the question that maybe Sjoukje can answer on what you can appeal in terms of this technical discussion to the court. If you want to add to Fergus's answer, please do.
Yeah, so basically what the Supreme Court can do is, well, what we can do is highlight certain flaws in the reasoning, for example. We can highlight if the court didn't take certain evidence into account or didn't interpret it correctly, for example. We can't bring any new sort of facts into the procedure, but it's really about checking if the ruling that is there is legally correct, and also if the reasoning makes sense. Basically, that's in sum what we can do. So we won't have a do-over of the facts, but we can point out certain flaws in the judgment. Yeah.
Yeah, thank you. So yeah, the question was about kind of what is the IPCC saying, or what do we need to hear from the IPCC in the future? And I think it's important to clarify here kind of what role does the IPCC play, and like what are its responsibilities? Because ultimately it's a body kind of appointed by the UN to summarize climate science, summarize what the scientific consensus is what the science is saying, to inform policy. And in practice, in recent years, we've seen that the IPCC has informed litigation and courts as well, in the sense that this is just kind of the highest level of science we have on climate change. So this is something that, you know, courts around the world, if they're looking for evidence for, you know, establishing the knowledge base on climate change, we usually see them in the first instance look to what the IPCC says, as well as national scientific bodies, which often are seen as having kind of the highest legitimacy in the eyes of courts. And so, but of course, what the IPCC does in its reports that it puts out every few years is that it summarizes the current state of knowledge on climate change. But maybe a challenge with this is that as soon as the reports are published, they're going to be behind the times, because the science is developing very rapidly. And so I think we can expect to see, you know, a lot more interesting kind of conclusions in the next assessment report in AR7 that will certainly inform climate litigation. So I expect to see more on this research I was talking about earlier on reduction pathways for companies, you know, how responsibility to reduce emissions should be distributed between different sectors, industries, etc. Another important point that the court already picked up on is that they found that, you know, for Shell to open new oil fields to extract new oil, that's probably not in line with Paris obligations. And the reasoning for that is that it probably wouldn't be in line with existing carbon budgets. You know, we have carbon budgets that basically tell us how much CO2 we can still emit in the future if we want to stay in line with the Paris goals, if we want to achieve the 1.5 degree temperature goal. And this is, you know, something we've been getting from the IPCC for a long time. And so I expect we'll see this in an even stronger fashion in the next IPCC report. So ultimately, it becomes a challenge when the courts have to deal with the very latest science that hasn't been validated yet by the IPCC, as we've been seeing in some recent cases. But ultimately, yeah, the IPCC is kind of the highest authority we have so far.
Thanks, Noah. Now, Mr. and Shauki, to you to answer. Also, feel free to answer other questions if you want.
I go
You want to
first?
start? And say?
So in terms of where are the roles, I really encourage you to read the part of the ruling where the Court of Appeal outlines EU climate law, because it's an excellent moment to kind of pause and reflect how many regulatory developments there have been in the past few years. And for example, the CSDDD, which requires large in-scope companies to both adopt an annual climate transition plan, but also through best means to implement it in line with Paris Agreement goals and EU climate law goals. And it's interesting to me that this argument of Shell, that it has this lack of control or influence over Scope 3 emissions, and as I mentioned before, it was rejected by the Court of Appeal, was also because the Court of Appeal said, well, no, these are your own emissions. These are not attributable to consumers. And regulations like the CSDDD are already kind of making this argument that you have the corporate responsibility for Scope 3 emissions. So I think what we've seen in the past few years is that the roles are increasingly being regulated. And I mean, the idea of a due diligence in human rights, environment, climate change, this doesn't just come now from CSDDD, but also this idea comes from way back, and this is also something that the Shell case draws on. It comes from the UNGPs, which originally was on human rights risks, but now through litigation and guidance, it's clear it also applies to environmental and climate change impacts. It comes from the OECD guidelines, which in 2011 included a chapter on environment, and now in 2023 was revised again to include a chapter on climate change. And the idea is for companies to do do due diligence, so to identify and mitigate risks, not just in relation to human rights, but also with respect to environment and climate change. So I think the roles or the expectations we can have of companies, they are already here, and it's becoming what was originally only in soft law is being hardened through both regulatory developments and litigation. This would be my point. I don't know if Schalke wants to add.
Yeah, I think I fully agree. Having a permit does not absolve you of your own responsibility. And I think the court was very clear about that already in the ruling in 2021 and clear again in the most latest ruling. As a company, you have a responsibility to cut your emissions. That responsibility is separate from governments. You cannot hide behind the government to absolve yourself of that responsibility. And also, yeah, again, the CSDDD, the court was also very clear that the obligation of a company could even go further than that, than what is stipulated in the latest EU regulations. Maybe if I can quickly go back to what Noah was saying, I think it's also really important to highlight once again why we were asking for the 45%, because that is what the world on average should be doing in 2030. And we really strongly feel that that is the absolute bare minimum that a company like Shell should be doing, right? Because Shell is responsible for so much emissions, has so much control, is based in the global north. And so we really try to position it as that, and that's halving your emissions by 2030 is also underlined in so many standards and guidelines out there. So yeah, it's really unfortunate that the courts didn't see that as enough consensus, because I think for us that consensus is clearly there, and at least it could serve as some sort of bottom line for what Shell in any case should be doing, because the court also said that Shell as a fossil fuel producer might be obliged to do more than the global average. So yeah, this point remains, I think, quite unsatisfactory, if I can put it like that. Yeah, and to come back on the first question, companies have their own responsibility regardless of what governments are doing, regardless of what consumers are doing. Yeah.
Excellent. Thank you. So wait, we have lots of questions from the online audience, and my colleague Emily Brandine will have collected and I don't know, found a way to filter 3. And so please share the 3 questions with us.
Great. Thanks, Joanna. And thank you very much to all of the speakers on this evening's panel. I'm actually going to be a bit cheeky and combine 2 questions into one. Great. So starting off with Charlotte Drews, who's asking or mentions, over the course of the commentary and presentations, the idea of gaps came up frequently. So for example, the governance gap that limits the control over corporations, the gap between courts and scientists, and lastly, the gap between the global need for climate change litigation and protections and the application to individual cases or companies. So can the panelists comment on what kinds of discussions or actions are taking place to bridge these gaps? And our second combined question is from Will Richards and Charlotte de Vitry. And they ask, they would love to get the presenter's view on some of the Easter eggs in the judgment and what this means for future climate litigation. So given what the court has said, and bearing in mind the challenges of communicating scientific evidence, what trends do you think we will see in how cases are framed and the causes of action that they are brought under? And what are some of the takeaways in practice or impacts that we can expect in the UK context? And then the final question is from Yuri Prado Muchida Lima. They're asking if there is a way for the judiciary to be more prepared to judge strategic climate change litigation cases, considering that the scientific consensus isn't necessarily working. Thanks.
Good. Excellent. Thanks, Em. I'm looking here at the time. It's we have 15 minutes more. And I think what I will do, if you don't mind, is to open to the floor and we can figure ways to combine. Yeah, we can do that. Good. So Ian, you have one question. Whoever else has questions, raise your hands. That's starting here.
Thank you very much. Ewan McGahey, King's College London, and as of last week, also Grantham Institute, LSE. Woo. I've got two comments and a question, if that's all right. The first comment is well done on doing the case. It's just fantastic, even if you lost at this. Sorry. And it sounds like from the room here, certainly you should probably appeal. I reckon your chances are pretty good in the Supreme Court because they decided agenda, and your chances are also pretty good in the European Court of Human Rights. I suppose, you know, with the Klimazinnieren judgment, the idea of the right to life being used as an interpretive aid in private law is super interesting. And if you get a European Court of Human Rights judgment on that, it'll be, I think, really, really powerful. Second thing is on the CSDDD that's been mentioned. The Sustainability Directive requires all companies to have 1.5-degree plans. And you might have heard that we're already warming this year by 1.5 degrees. So that logically means not just no new fossil fuel projects, it means shutting down as fast as possible. I mean, you forget distant targets by 2050. If you want to keep to 1.5 degrees, that means ceasing coal and oil and gas as fast as technology allows. The third thing, and this is where the question comes in on the market substitution argument. A couple of us were sort of wondering, you know, with this sort of first-year microeconomics logic, if you know, the supply curve shifting to the left, I mean, isn't the more logical way of thinking of it that if Shell doesn't sell the stuff, the oil and gas, then itself, then it might sell the asset to somebody else who then starts producing it, and therefore you don't get the reduction in emissions. But of course, this was an injunction. So I'm wondering if Shell was making that argument, if they could be stopped. But of course, this was an injunction case. And could you argue that a company like Shell shouldn't be allowed to sell off its assets to another producer that will continue to spout out coal and oil and gas? Because that in itself would be part of their emissions. And because, you know, scope 3 is a sort of malleable concept. And if I sell stuff to consumers, that's in scope 3. But if I also sell like the whole oil field to somebody else, then surely that should be caught by an injunction somehow as well.
Thank you. Tiff?
Thanks, Tiffany. I work at LSE Grantham Research Institute. I had a question if Shuka could comment on it. You mentioned the ING case, and I believe in that case, you are also asking, one of the claims is about a 48% reduction. But if you could comment on potentially what are the things you're thinking of doing differently, or which specific areas, you might be thinking about, if you can.
And is there any very last question? No, thanks. Well, yes, sorry, you're hiding there.
Thank you, Joanna. Lawrence Doering from Mishkondareya. I just have a very simple one, which is the quest for consensus when it comes to a reduction order setting the bar too high for the standard of proof that one could expect at a court of law?
Okay, excellent. We have several very good, many difficult questions, and we have 10 minutes to the end. So, but I did it on purpose because I like collecting questions. Your questions are questions that we are always interested in hearing. So what I suggest is pick whatever questions you want to answer and give a brief answer. And I trust you can choose and do a quick answer. So starting this time with, well, I guess let's go back to the order we started. Shuka, with you.
Okay, there were a lot of questions. I'm not sure if I got them all, but let me start with the ING one. What we're planning on doing with the ING case in any case is challenging the investments in new oil and gas fields that they're still massively financing. The other thing you mentioned, the 48%, yeah, that's the updated version of the 45%. Meaning that we are still going to ask for them in any case to also do at least the bare minimum, which is a global average that should be expected of such a big player that's active in the global north. There was also a question about the sale of assets. We actually did argue that Shell shouldn't be allowed to sell off its assets because our demand was always very clear. That's about a reduction of CO2 to the atmosphere. So yeah, we did make that point in any case, but yeah, the courts clearly didn't rule on that. Then on the idea of gaps, I think I can say that there are a lot of conversations happening on a lot of different levels, and we are trying to bridge the gaps in many different ways. And we are also really reaching out to scientists to help us with these sorts of cases. And yeah, we should be doing more of that sort of work to help us to continue to do these sorts of cases. And then maybe on the quest for consensus, I think that was one of the points that I also tried to make, is that what the court could have done is in any case choose a minimum, which they did in the agenda case. There was a bandwidth and they used the lowest range of the percentages. Now, in this case, the range that Shell suggested was very low, about 2 to 7%. But the court could have also chosen a reduction percentage that was a little bit lower, which was also one of our subsidiary demands. And yeah, I still think that we didn't over ask with the 45%. I think 45% is a very reasonable ask from one of the biggest polluters worldwide. Yeah, let me leave it with that, and the rest of the panel can answer some of the other questions.
Thank you. Yes, definitely. Thanks. You've covered already a lot. Noah, pick up whatever question.
Yeah, thank you. Well, there are a few different questions about kind of what's needed from the science, how like science comes into court that I can touch on. You know, there's a question of how can we prepare the judiciary? How do we bring courts and the science closer together? And I think this is a really key issue, that judges need education, need training on climate change. And we see that happening to some extent as well. But so it's important that judges are open to educating themselves. And again, like we've talked about before, we just need to find the best ways to very clearly communicate what the science is saying to the courts. And to touch on this point of, you know, what kind of consensus does there have to be? I would say that what we have to help courts understand is that, or we need to help courts be able to differentiate between proper science and what we might call questionable science, which we see popping up in a lot of different cases like this. And a broader dynamic we're seeing is that most of these big fossil fuel companies aren't denying climate change anymore. You know, climate denial is not cool anymore. That's very 2000, but so they're all saying, yes, of course, we're concerned about climate change. And like we heard, Shell consider themselves to be a leader of the energy transition, yet they're still refusing to take responsibility or accept any kind of legal liability, as we see here. And one of the ways they've been doing that is through very strategically funding certain aspects of the science. So like we heard in this specific case, we've seen that in other climate litigation as well, of these companies either directly or sometimes also indirectly funding science that's more in line with their arguments or with the legal and the broader normative arguments they're putting forward. And so I think we have to help the courts understand that, you know, some report funded by an institute, or that's written by an institute funded by Shell, or some, you know, published in some journal where you pay a $2,000 processing fee and you can publish anything, isn't comparable to something that's published in the top peer-reviewed journals that goes through very rigorous peer review. You know, that so this is something we have to help courts understand what good science is, and because obviously courts need to have a solid basis of information. They need to know what the knowledge or what the scientific knowledge is saying, so they can make informed decisions. And just to end with a broader point of, you know, what role science plays in all of this. So first of all, the science is very clear that we need action right now. Of course, there's a lot of discussion around, nuances about different aspects of climate change, but the science is very clear in telling us in broad terms what's necessary, what kind of, reductions we need, what are the climate change impacts that we need to address around the world. What the science won't tell us is the detail of exactly how we have to go about doing that. That's not the responsibility of science ultimately, that's the responsibility of climate governance, of our institutions. So in the first instance, our governments around the world should be taking sufficient action on climate change and should be compelling companies to take action to reduce their emissions. But unfortunately, we haven't been seeing that enough so far, even though there's a legal consensus which has really developed in the last few years around the world that climate change is a matter of human rights. It's affecting people's rights. It's affecting the rights of current and future generations. And so if governments aren't taking sufficient action and corporations aren't either, then we need courts to listen to the science and force governments and corporations to do something now.
Okay, great. So I'll respond to Ewan's question and then a sort of quick response that combines a couple of the first two of the online questions. So to Ewan, so you're absolutely right. And certainly Shell argued in its 200 and something statement of appeal, and then its 173-page expert report that responded to our 10-page, pro bono letter from Milieudefensie, that it made much of the fact that Shell could essentially sell its factors of production to another producer. So if we go back to sort of my diagram with this first scenario, it's not only necessarily that it would be other producers from producing in other oil fields that Shell argued would substitute for its production, but it could be other producers that take over Shell's assets, including potentially its exploration production licenses, and produced in oil fields that would otherwise be Shell's to produce. And so it said, well, so it won't make any difference. And we argue that even there, you're still putting significant friction into the production, right? So you're basically you've got these transaction costs, and we can reasonably assume that the actors that Shell sells to will not be able to produce as efficiently as Shell. That's generally how markets work. And so we argued that even there, even if they did sell its factors of production, it would still shift the supply curve, and you would still have an increase in the price of oil and gas. In response to the first two online questions, so one of the gaps that I think this case really highlights and that I've discussed is around not just the gap between the scientific evidence and sort of, legal norms and what courts can sort of reasonably judge, which has received a lot of attention, by NOAA and many others. There's been much less attention, we've found, to the complex economic and sort of technical energy related evidence that also often arises in fossil fuel cases, quite aside from the climate science. And that's basically the sort of scope of the evidence that I was addressing in my remarks. One of the questioners asked what can be done to bridge these gaps, some of these gaps. So one of the things that we've done at UCL, I've led a project with Professor Steve Pye in the UCL Energy Institute, to try and make a lot of that evidence, particularly peer-reviewed scholarly evidence around these economic and sort of related questions that's relevant to fossil fuels, available and accessible in a format that's useful to lawyers and to litigants. And that's available on something called the Redline database, redlinedatabase.org. So thank you for allowing me to get that plug in. And then just finally, I think sort of somewhat related to that, I think sort of for us, I think the key Easter egg is around this tantalizing prospect that potentially the duty extends to precluding sort of new fossil fuel investments. And I think, again, this highlights the importance in terms of things that we can do to bridge the gap, is to build some of these really clear red lines, these really clear norms. And again, I think focusing on no new fossil fuel projects is something that I'd strongly advocate.
Isa, your last word.
Brilliant. I have two comments I would like to respond to. And the first one is in response to Laurence's question, if the consensus is too high. And I just want to really draw the parallel again, we've discussed it, to the Uganda case, as the Supreme Court in the Uganda case came to the conclusion that a specific emissions reduction was able to impose on a state. However, one must acknowledge, of course, the contexts are different. One is a case against the government, one is a case against a company. However, what I find interesting is that this consensus was actually a range. So the consensus was on 25% to 40% of what developed states must do. And in the end, the Supreme Court imposed a minimum emissions reduction obligation. And this is also what Schalke mentioned. What they asked of in this specific case was a minimum emissions reduction obligation. And I find it interesting. I mean, we've talked about effectiveness, and Fergus has already highlighted that the Supreme Court took a different turn in the Uganda case there as well. But in terms of scientific consensus, that a scientific consensus was not able to be established on a range of what might be required, I find that quite interesting, and will be also following developments if the case will be appealed to the Supreme Court. And the second and last comment that I would like to make relates back to the gaps and what is happening, what discussions are happening to bridge that gap. And I would just like to maybe tie it back to climate litigation, how we really see this field diversifying. And I will plug Joanna and Kate's report, which is coming out every year, which highlights these trends really nicely. And what we've seen in the past year, or maybe the past couple of years, is that this increasing turn to international climate litigation. So around the world, people are turning to international courts and tribunals. And what we see is now we have 3 advisory opinions, one before the International Tribunal for the Law of the Sea. There was a landmark advisory opinion that was issued earlier this year, and now we have a pending one before the Inter-American Court of Human Rights, which I think will definitely answer to the responsibilities of corporations in the context of the climate crisis. And we have a pending opinion before the International Court of Justice, where the hearings will happen next week. And to also maybe comment back to what are the discussions happening, how can we bridge this gap between the scientists and the courts? I am tying it back to what is happening at the International Court of Justice. Just this week, the judges of the International Court of Justice met with IPCC lead authors to discuss the overwhelming amount of climate evidence that was handed in international advisory proceedings before the ICJ. So I think that we are seeing how increasingly around the world, people are turning to courts. They are using different and diverse litigation strategies in order to seek to bridge these gaps that we're seeing.
Look, it's exactly the time to finish. I think 90 minutes went by so fast. This was fantastic. It was a tour de force. I think the panel deserves a huge round of applause. Thank you so much. Well deserved. And just before we finish, I want to say a few thank yous. So first, Kate Hyam, who thought about having this event, responding quickly to the decision. She's not sitting here, but she is always present. So thanks, Kate. Thanks also to Shirinas and Alex, who always support us organizing these events. Thanks to Emily Bradin, who did all the questions and communication around. Thanks to the colleagues from the law school, who we are delighted to see here. Really, thank you very much for coming. Maybe you're missing on a big party downstairs. And huge thank you to all of you present here, all of the more than 100 people who joined online. It's really amazing to see so many people interested, following, asking questions. So huge thank you, and hope to see you soon. Thanks again.